Court of Appeal Limited 4 of the 5th District of the State of Florida is now in session. The Honorable John N. Harris, Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning again. This is the regular panel for today's docket, scheduled at 10 o'clock this morning. Again, I'm joined by Judge Brian Lambert and Judge Scott Makar. For those of you who weren't here earlier, if you happen to have any cell phones or other noise-making devices on you, please go ahead and make sure that those are either silenced or turned off at this time. Each side gets 20 minutes for their argument. Appellant can reserve as much of that as you would like for rebuttal. We'll set it at 5 minutes, but if you want anything other than that, please just let me know. All right, our next case on the docket today, Security First versus Echevarria. 24-1476. Counsel for appellant, you may proceed when you're ready.
May it please the court, good morning. Mark Tinker and Jose Campos here on behalf of Security First Insurance Company, and I would like to reserve 5 minutes, please.
Okay.
I'd like to start with the coverage issue, not only because it's potentially dispositive of the whole case, but because that is the reason that we requested oral argument to begin with, because it's an issue that does affect more claims than just this one. It's a policy issue that has been litigated throughout the state. This court has seen that through the opinions that we've discussed in our briefs. I would like to say, or it's tempting to say that this court has considered the issue twice in Vasquez and Diaz, but I don't believe that's entirely accurate because the court in Vasquez never ruled on the issue. The parties stipulated to the coverage question, the actual existence of coverage, so it was never something that the court considered or ruled on.
Is that the main thing that distinguishes Vasquez in this case? Is
Yes.
the stipulation?
Yes, it is, Your Honor. I believe that's the only thing that creates any distinguishment.
What about the language that's used?
There is slight differences between the People's Trust language and the Security First language, but the differences, as described, I think, in the Gunzer opinion, are most aptly, the distinction is in the limited water damage endorsement itself. And once you get to that point, the coverage has already been otherwise excluded. So the only difference that has been discussed is the difference in the whether the limitation, the $10,000 limitation, is going to apply.
And Gunzer was the one written by Chief Judge Traver at the 6th.
Yes, sir.
And then Diaz came out shortly after that, right?
Yes.
Okay.
So, I believe that once you get to, if you look at the controlling language in the main policy, these are, standard HO3 policy forms that People's Trust uses, Security First uses. The main language says that, if any of these causes of loss, and we're looking at wear and tear, rust and deterioration here, if any of those cause water damage not otherwise excluded, then tear out exists. They're both identical in that respect. The water damage exclusion endorsements that these insurers select for a premium credit does otherwise exclude the loss. There's no question there as well. And so when you get to, like I said, the only difference is you get to the limited water damage coverage endorsement. They're both identical in that they do not extend coverage for tear out costs. They cover sudden and accidental direct physical loss by water. Tear out is none of those things. It's not sudden, it's not accidental, it's not a loss by water. It is intentionally people with jackhammers and things tearing up floors and ripping walls apart to get to pipes. So the only differences are differences that don't make a difference. So that I believe the stipulation was the one and only controlling factor that makes Vasquez what it was. And like I said, Vasquez never decided the coverage issue because it was stipulated there. So that is not something that I believe creates any precedent. And one of the things that we did file just about a week and a half, 2 weeks ago, was the cost opinion, which I filed to show that it does not matter as far as the policy. That was a St. John's policy that had actually different language that created, they used the water or sewer that backs up through drains exclusion. So it wasn't even a water leaking from pipes exclusion, but they looked at it and said because the loss is otherwise excluded by that water and sewage backing up through pipes provision, there is no tear out available under the St. John's policy. So it's not, this isn't a policy specific thing that's unique to People's Trust. I think the issue is that straightforward. Unless the court has any other questions on that, we do have two other issues that were raised. The first is a directed verdict motion that was made at trial.
If we rule in your favor on that first issue, that's dispositive.
Correct. Yes. Neither of the other issues matter, but I think I'd be remiss if I didn't address them. The directed verdict issue, I don't know if that's something that really even lends itself to argument particularly because we put down what we believe the evidence showed. I know Mr. Nation did the same, but there are two things that I'd like to point out with it. The first is that you have Mr. Jeremko, the plumber, who admitted on the stand they had just as much evidence that this was a one-time event versus something that would require the pipes to be torn out and replaced. So he said, just enough, it's 50-50. And then when the directed verdict motion was made, the trial judge said, well, I understand that Mr. Jeremko said it could be A, B, C, or D, but the jury can pick between those things. And I believe that's wrong. The jury cannot look at something that has just as much evidence and look at something that there are four choices, and it could be any one of them, and just pick one. They have to have more likely than not evidence. And when he says, I have just as much evidence, but it's one thing versus another, that's not more likely than not. So the directed verdict issue is, again, I think it's something that is just something that the court can look at, the evidence that we put forth in our briefs. And then the third was the motion for a new trial that was based upon the change in the estimates. This is a claim that started out with, I want to say it was $116,000 was the estimate.
The last estimate is actually, you guys like that number best compared to the other ones. You're just saying because there's been a changing in the estimates that goes to the credibility of their testimony.
It goes to a couple things. Yes, the credibility of the testimony. You have an expert who, it's not just about the dollar amount. He changed the entire scope where he originally said the entire house needs to be replaced. And by the time he got to trial, said, no, it's just the downstairs. So the jury can say, how are these pipes getting better? Why did you think they needed to be replaced before, but not now? That goes directly to his credibility. And I think the way that it was argued too at trial was to come in and, if you read the jury selections of voir dires in any of these, homeowners insurance cases, you see what jurors start out thinking about homeowners insurance carriers. It's not a favorable environment to begin with. And if they come in and say, all we're here to do, this is a 2019 claim, it's been litigated for years, and all we're looking to do now is get $26,000. We just want them to pay a little bit more. Big bad insurance company, that's what they did. And the jury's not told that before suit was filed, they wanted 400 times that amount. The jury is prejudiced against the homeowner's insurance carrier in that instance, and it doesn't get to learn about the credibility issues. So those are the three issues. I haven't even come close to my time unless the court has any questions. No. Thank you, and we reserve time for rebuttal. Thank you.
All right. Thanks, sir.
Good morning.
Good morning.
Mark Nation on behalf of the appellees. I want to focus on first on the transaction between Security First and Mr. Echeverrian. They sold and he bought a policy that Security First says, and they base their premiums on this. The unambiguous policy language dictates the only source of coverage for water damage, including tear out, is a limited water damage endorsement. So when he bought it, they based their premiums on that understanding. He paid for that coverage. They later want to change their minds. The benefit of the bargain for him is that coverage is there. When we look at it, and they're not entitled to that windfall, that's how they interpret their policy. They say that's how the benefits are paid. That's how premiums are determined, based on that. They told the Fifth DCA that exact thing. You've read the quotes. But these are statements of fact that they are using, or saying is how their policy is to be read. Unambiguous language of the policy dictates the only source is the limited water damage endorsement for water damage and tear out. In specific questions from Judge Evander during oral argument, they were asked these questions that they're now backing away from here.
Oh, you're talking about Vasquez.
Vasquez, yeah. In Vasquez. The briefing in Vasquez, I apologize for that. They say the unambiguous language of the policy, the limited water damage endorsement, grants coverage for tear out and water damage. And they told Judge Evander that too, two very specific questions.
We don't follow what someone says in oral argument, we follow precedent. And I can't find any case other than Vasquez, which I think is potentially distinguishable, that supports your view of the language in the policy. So if you could help me out on that.
Yeah, and I agree that the People's Trust cases and Diaz say what they say. But I think we have to put it in context, and we can't ignore the fact that they've told insureds, and I put this in the summary judgment evidence, they tell their insureds that's how the policy is to be adjusted. They told this court that, and they've said it in Nichols in their briefing after Vasquez.
What's your best case today? I guess it's Vasquez. Is there anything?
Yeah, and that is the best case, because that's where they said how their policy is going to be interpreted. And they mentioned there's no equitable estoppel. There is. There certainly is. When they base their coverage, they know what their coverage is, and they base their premiums on that coverage, and the insured purchases that coverage. That's equitable estoppel right there.
Does Vasquez predate Panettiere?
It does. Yeah. It was the first one that came out. And then, I think Panettiere came out before Nichols was written, before the briefs. And they said, you don't need to look at Panettiere because our language is different. So how did they come up with the conclusion? How did Security First reach the conclusion that the limited water damage endorsement granted coverage for both? Because that was their conclusion. And if you look at the language itself, they read it as a whole. What the court did in Diaz, and with all due respect, I don't know that this argument that I'm telling you right now was made. They looked at it not.
We didn't have oral argument that.
Oh, you didn't? Okay. Then how was this policy sold? There's a main form of the policy. There's a water damage exclusion, and there's a limited water damage endorsement. It's sold all as one piece. When it arrived in my client's mailbox, there was never an exclusion for water damage. It is not otherwise excluded. You look at it as a whole, where is sudden and accidental direct physical loss from a plumbing system excluded? It isn't. The policy shows up with subsection 5 of the exclusion out, because they bought all 3 pieces of this policy, including the water damage, limited water damage endorsement. It was never excluded. So how can they then turn around now, and they agree with that? That's how they reached the conclusion in Vasquez and in Nichols, and to their clients or insurance, and to the Office of Insurance Regulation. They reached the conclusion that when you buy all 3 of those together, reading it as a whole, you get water damage and tear out with the limited water damage endorsement. Why? There's only one explanation: because water damage is not otherwise excluded. And it is as simple as that. It wasn't excluded for some period of time and then brought back in. This policy was never, ever excluded, never excluded water damage from a plumbing system. That's what they bought, sold, and that's what my client bought. They reached that conclusion looking at the limited water damage endorsement as a whole, in conjunction with the other parts of the policy. Doing that, Judge Maker, I'll use the language used in Jerisa James, State Farm. For the life of me, I can't figure out.
That's dangerous.
I think it was, for the life of me, I can't figure out, now, how, you're talking about the incurred argument in that, how this was ever excluded in the Security First policy. It cannot be otherwise excluded. It was never excluded. And so we know that also because I've put into evidence their new limited water damage endorsement. And if you look at their new limited water damage endorsement, the grant of coverage at the top is exactly the same as it is in this case. It doesn't change. The limit of liability then says the limit is $10,000 for water damage and tear out. Why would that be in their limit of liability when it's their argument today that there's no coverage at all for tear outs? And I also put People's Trust, new one, in evidence. What did they do?
How would we write an opinion in this case supporting you that wouldn't come into conflict with the other DCA's opinions and perhaps some of our own?
I think
How would we distinguish?
there are a couple of ways. We look at how Security First, this policy as a whole, and I don't think the opinions address this. We look at how it operates as a whole, and you can say, based on this policy, the way they sold it and the way they interpreted it at the time they sold it, it was never excluded.
So what I'm hearing is you're saying that we would write an opinion saying, yeah, the policy says this, the text of the policy says this, but they marketed it a different way?
Well, every case has different facts, and I've put more facts into the record here than I know were in Diaz. I suspect in the other cases too. And you can say, based on the record in this case, consistent with Diaz, Security First when they sell this policy, they sell it with water damage and tear out included. And leave it at that, but you can go a step further.
So wouldn't that be like a misrepresentation claim versus a breach of contract claim?
I don't
They
think so.
misrepresented the sale of the product?
No.
Or the-
I think they represented it 100% correct because it is not otherwise excluded. I think they were correct in that assessment, in that determination that they made, that limited water damage and tear out are both included in there, in Security First policy. And there's another one, two other ways. Looking at the limited water damage endorsement, they based that representation to the court each time on the fact that the limit of liability is per loss. And that's different language than People's Trust. People's Trust limit, and they're going to say don't get to the limit. That's not how they interpret it. People's Trust says per all covered property. They say Security First per loss. They then say, reading that as a whole, tear outs included. The next way you can get equitable stuff. They have told.
When you keep saying that's not how they interpreted it, I mean, at some point they filed a motion for summary judgment saying, this is how we interpret this, and they were unsuccessful, but now they're saying, but now look at Diaz, look at Gunsler, look at Bank, look at all these cases, our summary judgment is correct, how we interpret the verbiage, and it seems, maybe I'm missing the connection here, you seem to be saying, look what they said before in Vasquez and whoever, and now they've changed horses here because they've gotten some fortunate DCA opinions, and they shouldn't be able to do that in this case. Am I misstating your position here today?
Not totally, but a little bit.
Okay. Oh.
How is it not ambiguous if they can't interpret their own policy? They're not able to determine, now they're given a third interpretation of how this should be read. They don't know how to interpret their own policy. That's the only thing they can say. That renders it ambiguous. But getting to equitable estoppel, they tell us how they're interpreting it. That's how they interpret it. They sell a policy, charge a premium based on their exposure. Mr. Echeverria and everybody else buys that policy. They then take it away from them after they've paid the premium. They've not refunded the premiums. Any of the premium, they paid for that coverage. That's equitable estoppel, and that's reliance. There's another doctrine, quasi-estoppel. Quasi-estoppel does not require reliance. These aren't our briefs, but looking at the estoppel stuff, this pops up.
You know, these issues you raised below.
Estoppel we did, and I would say quasi-estoppel, not mentioned, but we are the appellee. This supports that finding. Case law is clear that with quasi-estoppel, a party cannot take inconsistent positions.
What was quasi-estoppel brought up below?
No.
So you're raising this for the first time before us today.
Under tipsy coachman.
That tipsy coachman requires it to be supported in the record.
Well, the issue of estoppel is raised. they raised it, and we've addressed it. And I do agree, it's not in there, and if the court needed supplemental briefing on it, happy to do that. But the doctrine does apply. And I'll just tell you what it is. And this comes from a 1900 case that's been utilized all the way up to PCAs and the federal courts. This is from a federal court opinion, A&E Body versus 21st Century. Florida courts describe quasi-estoppel as a legal doctrine applicable in certain limited circumstances which provide a party cannot either in the course of litigation or in dealings in paius, this means outside of court, occupy inconsistent positions. And it's similar to equitable estoppel, but it does not require a misrepresentation by a party or reliance. That is the argument we've been making, saying that they can't read their own policy, so it has to be ambiguous. It's not ambiguous, it's got to be quasi-estoppel. And if it's not them, there's equitable estoppel here with reliance. What reliance was they're paying the premium, but also we litigate these cases, take cases to trial based on what they've said. And they've said both are covered under the limited water damage endorsement. But the final thing on the limited water damage endorsement, I did talk about their limited water damage endorsement, where it's in the record. The grant of coverage is exactly the same. The limit of liability then limits water damage and tear out. Why would they do that if there's no grant of coverage that they find available for the tear out? It makes no sense whatsoever, and it's consistent with how they've been operating with their insurance, with the courts, and with the OIR on this. Any other questions on that?
Just clarify one thing.
Yes, sir.
The briefs keep referring to the WDE in this case. We keep calling it water damage endorsement. They call it water damage exclusion. What does the policy say?
The water, there are three provisions. They're all insured against. There's a water damage exclusion, WDX, I think we call it. Did we?
I thought WDE, but
Okay, water damage, yeah. And then the LWD, limited, those are the three things. So whether it's the water damage exclusion or the WDX, water damage,
so what does the exclusion then provide?
it has, I think, 8 subsections. Subsection 5 is if my client had bought without buying the limited water damage endorsement, that would apply to this claim. It's water escaping from the plumbing system. They bought it together, all as one policy. And when I say in my briefs, it's as if subsection 5 is deleted, that's what I'm talking about. The water damage exclusion endorses over that. The limited water damage endorsement endorses over that as a single document. And so my client's water damage was never excluded. I don't know how it was excluded for some period of time, but it just was never excluded. As to Mr. Dremko's testimony, he was asked on direct or cross questions, hypotheticals. He addressed those hypotheticals, but on redirect, he made it crystal clear. Now direct and redirect, he made it crystal clear. The cause of this loss was the condition of the pipes working together, the restricted internal diameter, the pack pitch, and there was an opening in the pipes which was damaging the fills. They didn't fill, which was entering the pipe, and the damage to the fill occurred during the policy period also. And there was no way to fix this other than addressing the entire system. I think that's replete. We've cited all that testimony. And when counsel said just enough evidence for one or the other hypotheticals, they left out an important issue. When I got back on redirect, do any of those issues exist here? No, they don't. And does the fact that they have ongoing problems after the piping up until today factor in that opinion? And the answer is yes. And so his opinion, that was up for the jury. They argued that to the jury and were unsuccessful in that.
So that was properly a jury question. The motion for directed verdict was correctly denied.
100%. That's correct. Both sides could get up and argue that, and they did. As to the triad estimates, we're allowed to withdraw a claim. We withdrew it. The record is clear. I did that as a tactical decision under Cataldo. We were allowed to do that, and I put forth why. Where they had an expert who was going to testify, nothing wrong with the second floor, doesn't need to be done. I said on the record, we could push that issue. Mr. Jarenko would have reasons for that. But I decided as a tactical reason, we're going to withdraw that part of the claim, focus just on subsurface. It would turn Cataldo on its head. We can withdraw that claim. That's a collateral matter now, and it doesn't go to impeachment. Nobody said the pipes, I didn't ever say, and no expert said, the pipes were fine upstairs. It was a tactical decision. We didn't say, well, they got better. They said that we wanted to cross them on how it got better. It did better. But I made a decision not to pursue that. So, let me see if there's any. Now, we made no argument whatsoever this is a big bad insurance company in this case. I don't do that, and you'll see nothing in the record about that. We made it 3 arguments. Direct physical loss during the policy period. We ended up having to step into it in this case. Was tear out necessary? That was our burden of proof. Based on the facts, based on the evidence, was it necessary? And if so, what's the extent of that tear out? Those are the arguments made. The court was right. It's well within her discretion to keep in or out that evidence when it has no relevance to the issues actually being tried. And they could cross-examine both experts on prior, us hiring them in the past and using them in different trials. Fair game. But this
It was the same guy in Jarenko as the one you had a couple weeks ago.
2 weeks ago.
Yeah.
It's not the only one, but he's been in a few.
Yeah.
So we're looking for an affirmance, and I appreciate it. Thank you.
Mr. Johnson.
Just a couple of things. I heard several times in there that this water loss was never excluded. And to say that is to pretend, Judge Harris, you asked, what is this endorsement called? It's called the Water Damage Exclusion Endorsement. And it goes back and modifies the exclusion section of the policy. It says the original water damage exclusion that's there is being replaced by this laundry list that is entirely comprehensive that will exclude this.
Is your position is that this could have been a covered event, but the Echeverrias chose coverage that was not as expensive and they got what they bought?
Correct. They got a premium credit for the water damage exclusion endorsement, and then for a lower premium buyback about this limited form of coverage.
And if they had chosen not to do any of that, and this could have been a covered event at a higher premium, is that what you're?
Yes,
That's what you're
absolutely.
saying, the record shows us that?
Without either of those endorsements, this would be covered, yes. And the tear out would be covered up to the coverage A limits. It wouldn't even have any sublimit or
And the amount involved would have been fully compensated if under the earlier version of the earlier version is not correct, under the policy that they could have bought.
absent these endorsements.
Absent these endorsements.
Yes.
Better phrase.
And, I think that is the thing, is to say that this cause of loss, and that, loss is a key word. Panettiere emphasized it all the way through, and I think Gunser did as well. But the original loss was excluded by this water damage exclusion endorsement. And that original loss is the only place in the policy where you'll find tear out mentioned, where tear out's going to be covered. Because when you get to the limited water damage coverage that they bought back, again, that only applies to sudden and accidental direct physical loss by water. Tear out is not any of those. So it doesn't give you any tear out back. The original loss was excluded. That is the reason for all of the opinions that this court agreed with. And I think there was actually a quote in Diaz that said, "We agree with our sister districts that the limited water damage endorsement does not recreate tear out," or I forget the exact phrasing of it there. But it was,
I wrote it, I should look at it.
that was the court's conclusion, is that this second endorsement, the limited water damage endorsement, doesn't recreate the tear out that was already
Maker said
done.
about himself, I gotta watch what, it's always dangerous to quote me about stuff I said.
That's it. If it was already gone and the new endorsement doesn't buy it back or doesn't recreate it, then that is the exact issue. That's what we've been discussing here.
And Diaz also mentioned that Vasquez was distinguishable for the reasons the sister courts all have.
Correct, and all of them unanimously said that the distinguishing factor was the stipulation. Gunser was the only one that talked about any difference in policy language. Again, it was looking at the difference within the limited water damage endorsement, which if you've gotten to that point in the analysis, it can't buy back what was already gone because there is no tear-out coverage created there. The only other issue I want to address is there's been some discussion of estoppel. Estoppel isn't, you won't find it in any of the pleadings below. It was argued as, Security First are taking inconsistent positions. But the Florida Supreme Court tells us you cannot, in the context of insurance, you cannot create coverage by estoppel. It cannot serve to extend coverage that's not in the contract itself. It can work against a forfeiture of coverage. And it requires an element of reliance. And I think here, for example, if Security First had said, yes, the Echeverrias, you have tear out covered, and they went in and started ripping their walls apart, they would have an argument. None of that happened. So it's not in the pleadings. There is no reliance here. We're looking at just the plain language of the contract that I think this court has already interpreted in Diaz, and so have all the other courts that we've discussed.
To be clear, the jury verdict here was for $26,000.
Yes, it was for the exact.
That's all that's the issue in this case before us today. It's
Correct.
$26,000.
The water loss payment was agreed to. It was a minor loss. It was a toilet overflow. I think it was about $600 that was paid just for some damage to baseboards and things. So all we're talking about is the tear out.
That's all that was tried is this tear out cost, I mean, is it reasonable or is it recoverable under the policy?
What was tried, because the judge had already decided on summary judgment that it was covered, what was tried was whether it was necessary. Unless the court has any other questions, thank you for your time today.
Good. Thank you, Counsel.